Hello, everyone. My name is Mackenzie Bretz, and today I will be presenting on the topic of what to do after a DVPO has been entered against an ex-partner or a person in your life. So let's get right into this. The first thing we always tell people is to, after a valid protection order is entered, you're going to want to make sure you obtain certified copies in case of violations. So this can mean different things in different counties. But for example, in Snohomish County, you would go upstairs to the second floor to the clerk's office, and you would get in the payment line and you would request a certified copy of the final order that the commissioner has entered. Typically in Snohomish County, certified copies are $5 for the first page and $1 for each additional page. So you want to make sure you bring your wallet with you to court. This is important because having a certified copy allows you, if you ever have to call the police in case of a violation of your protection order, you can provide them with a certified copy and they're able to move forward in the process of either prosecuting a violation or other next steps. We also suggest that getting more than one certified copy, so you can have one in your car, at home, at work if necessary, right? So you don't have one copy that you're having to bring around different places and, situations where you then forgot your copy and you don't have it when you call the police. Plus, if you have children, you're going to want to get a certified copy to provide to their school if they are included in this protection. Next, make sure the other party has no access to any of your media. So this is a really broad topic, but I think it's something good to think about and touch on. If there is a valid protection order, the opposing party somehow accessing your personal information is likely a violation of the order. However, making sure you have done everything in your power to make sure that accounts are separated, they don't have accidental access, or they don't have access that you may not know about is likely in your best interest. Many people these days are unaware of how much our media is intertwined with our partners. So this could include iCloud sharing, location sharing, photo sharing, Ring cameras, smart home features, email access, phone bill access, the list goes on. And you can think of potential consequences of those things being shared, right? If we have a shared photo account and you are taking photos of yourself, of your children, those are being updated, and the person who the protection order has been entered against gets to see those new updated photos because of their access to that account, that can feel really scary, especially if court has entered no contact against this person, right? So we always advise that you should go through all of your accounts, make sure sharing is not active, change passwords if necessary, make sure formerly joint cameras are no longer shared. So thinking about, if you have a Ring inside your house or even outside your house, and both parties had access to the account, how are we making this just your account now so the other party doesn't have access? Taking these steps to make sure all of these accounts are yours and yours only. It's going to help you make sure you feel a lot safer, especially now that your protection order has been entered. Okay, next question. Did the court order a civil standby? So what is a civil standby? So sometimes in a protection order, a court will order what we call a civil standby. This means if you requested, say, your partner be removed from a joint home, and the court said yes on that, they may also order a civil standby. This allows the partner to return to the joint home and retrieve limited belongings with the presence of police. So, say you're at a hearing, the court orders that the person no longer go back to the house, right? likely that person's not going to have toiletries, immediate clothing, maybe work items or tools that they need. So it allows them to get access to limited things to be able to properly proceed with their life moving forward. Sometimes this is beneficial, sometimes it's not. But if you requested one and a court ordered it, here's some things to keep in mind. Once a civil standby is scheduled, sometimes it's helpful to have a third party be there with you. This can just mean someone to help you feel more comfortable, keep you calm. Obviously, there's going to be police there, and they will do their best to separate both parties and kind of walk with the party who's accessing things from the home. Sometimes it's helpful to have a safe person with you that makes you feel more comfortable rather than just the police. Additionally, sometimes it's helpful that if you have children or shared children, if you're able to have someone else watch them during the time of the civil standby. This can be a sad, upsetting process. Arguments could potentially break out. It's always in the child's best interest if they're not there to witness this kind of unravel. So if you are able to have the child stay with someone during this time, that's definitely helpful. Also, this should go without saying, but it is not advised to dispose of any of your partner's things, as that can escalate the situation and potentially create bigger issues. Next, was treatment or an evaluation ordered? So typically, if you're seeking a domestic violence protection order, you would have to request from the court that either treatment or evaluation be ordered. These can be different kinds of treatment, including mental health treatment, drug or alcohol treatment, or domestic violence perpetrator treatment. Typically, first, if a court is deciding that they want to order some kind of treatment or there is substantial evidence that potentially the other party suffers from one of these things, right? You've provided evidence that the other party has severe mental health issues. You've provided evidence that there is a drug or alcohol problem and there's kids involved. You've provided evidence that there's severe domestic violence and there's children involved, right? Those are circumstances where a court may order an evaluation. So first, an evaluation is to typically determine if the person has enough of a problem to enter into treatment. As the victim, you are often allowed to be a collateral contact, meaning that you can contact the program and give your side of the story for the evaluation. This is often very important, as an evaluation based solely off self-reporting can often be inaccurate. So this is sometimes, if you are proceeding on your own, a place where you have to advocate for yourself, right? Advocate for finding out where this person is obtaining an evaluation, advocate for contact with this evaluator, and advocate for being able to properly and fully tell your story because you have the ability to do so. That information can go into the evaluator's determination of if treatment is necessary. So up on my screen, I have an RCW, which relates to domestic violence perpetrator treatment, and this is an important one. And if you're kind of going down this road and potentially the other person is required to complete some domestic violence perpetrator treatment, this is a good area to look into. So this RCW has requirements for domestic violence perpetrator treatment providers, things that they have to comply with to be proper under the law. And so one of those things is for safety checks and case monitoring. The programs are required to have the perpetrator sign a release of information for both the victim and the victim's attorney. Typically, this is called an ROI, or a release of information. So if you have a person who has entered into domestic violence treatment program, you have the right to ask that an ROI be provided. because it is required under the statute. There's some other things that may be helpful to look at under the statute, and helpful to look at to determine, maybe you suspect that your partner, ex-partner is attending a treatment that is not above board, or is, not properly providing treatment that is actually helping the person, right? So some of the things you can look at are the sessions in these programs have to be done in groups unless there's a clinical documented reason not to. Treatment must focus primarily on ending violence, holding the perpetrator accountable, and changing his or her behavior. So is there evidence that these things are happening? I know it can become a little complicated looking at an RCW, but this is definitely an important place to start to help you hold providers accountable for taking their job seriously, as typically people are required to take treatment who have committed serious acts of domestic violence. Overall, we understand that going through this process is an emotional and very demanding emotionally. And it's demanding of your time, of your family presence, all of those things. So we here at Beresford Booth Family Law Attorneys have ample time to answer questions, work with you on next steps after a domestic violence protection order is entered, and make sure that you and your family are fully protected. Thank you so much, and have a great rest of your day.